In this video I want to take a look at something that it's an implied term, and it's implied into every contract of employment, and it cuts both ways. In other words, it applies to both employers and employees. In every contract of employment there is implied into it a term that each party will have the trust and confidence of the other party. In other words, there's a mutual obligation to maintain trust and confidence between each other. Let me just explain that in a little more detail, or a little plainer, I suppose. Basically, if an employer gives an employee a contract of employment and fulfills each and every term or condition that's set out in the contract of employment, then you might say, well, once the employer does that, he cannot be in breach of the contract of employment. But that's not the case, because even though it's not expressly stated in the contract of employment that the employee is entitled to have trust and confidence in the employer, it's an implied term, and it cuts both ways. And what this really means is that even though an employer may abide by all of the terms and conditions of the contract, he may or she may behave in such a way that it's unreasonable to expect the employee to continue on in the employment. In other words, it's reasonable for the employee to look at the behaviour of the employer and how bad it is. It's reasonable for the employee to actually leave the job then, on the basis that the employer's conduct is so unreasonable that it is clear that the employer no longer intends to be bound by the implied term of trust and confidence, mutual trust and confidence. And the employee then is entitled to leave the job and bring a claim, successful claim, for constructive dismissal, or indeed wrongful dismissal, because it will be a breach of contract situation. But just to get back to the constructive dismissal situation, this would cover a situation where the employer's conduct is so unreasonable that it will allow an employee to say that employer is essentially treating this contract at an end. That employer is repudiating this contract, even though he's not expressly breaking any specific condition or term in the contract, and I'm entitled as an employee to treat the contract at an end and leave the job and bring a claim for constructive dismissal. This is essentially one of the tests to do with constructive dismissal. It's one of the tests that focuses on the conduct of the parties and the reasonableness of the conduct of the parties. Now, it cuts both ways, and by that I mean that the employer is entitled to give reasonable direction or orders, or whatever you like to call it, to the employee. And if the employee refuses to follow the reasonable directions of the employer and refuses to follow essentially the terms and conditions of employment, well then, in those circumstances, the employer is entitled to terminate the contract on the basis that he no longer has trust and confidence in the employee, because it's gone, because it is, again, because of the reasonableness or unreasonableness of the conduct of the employee. To bring it back to a constructive dismissal claim, and I've made a number of videos about constructive dismissal and about unfair dismissal, but to bring this back to a constructive dismissal situation, there are essentially two tests that you need to look at if you're going to assess whether you have a claim for constructive dismissal or not, or whether as an employer you're going to have to try to withstand the claim for constructive dismissal. And those two claims, or those two tests, are essentially: one, has the conduct, or has the employer essentially repudiated the contract of employment? Has he shown that he is no longer going to be bound by the contract of employment or by one or two specific terms which are fundamental to the contract? If that's not the case, the employee may still have a case for constructive dismissal, because that will be based on what I have just described to you now, the implied term of trust and confidence. In other words, is the employer's conduct such that the employee is entitled to consider the employer's conduct so unreasonable as to be a repudiation of the contract, because it's a repudiation of the implied term of trust and confidence. These are essentially the two tests which you need to look at in a constructive dismissal case, and if you're thinking about leaving your job, then these are the tests that will be applied by the Workplace Relations Commission or the Labour Court or whatever tribunal or court you find yourself in. I hope you find this useful. I've made a number of videos about employment law in Ireland. I've made a number particularly about constructive dismissal, but I wanted just to try to clarify and elaborate and colour in to a certain extent the two tests, breach of contract and the reasonableness test. So was there a breach of contract by the employer, or was the conduct so unreasonable that the employee was entitled to take the view that the employer had repudiated the contract by repudiating the implied term of trust and confidence? It was no longer there, and the employee then is entitled to treat the contract as being at an end. If you find this useful, please give it the thumbs up down below, and you might be interested in my YouTube channel. If you subscribe, you'll get notifications of new videos, and there is a lot of information, a lot of videos about employment law in Ireland, and indeed about all aspects of law in Ireland. My name is Terry Gorry. I'm a solicitor in Enfield, County Meath. In terms of assessing the reasonableness of the employer's conduct, just a couple of things that I need to say. One, it's an objective test. So the intention of the employer is immaterial. It's the actual impact, the objective impact of the behaviour on the employee. That's the first thing. So it's an objective test. The second thing that I'd say is that it is not, there doesn't have to be a one-off incident. It could be a cumulative series of events or occurrences which are unreasonable, and essentially it's the cumulative nature of it that will eventually lead to a last straw situation. And in the last straw situation, the employee then may have had enough. That one incident, the last straw, may not be of its own accord a sufficiently grave breach of the contract of employment or a sufficiently grave piece of evidence of the repudiation of the contract by the unreasonableness of the conduct of the employer. However, that last straw, that last piece of evidence, along with the previous incidents, the cumulative effect may be sufficient to allow the employee to bring the claim for constructive dismissal, a successful claim.